Thank you for joining today's webinar, Prepping for QM, The Fact, Just the Facts, sponsored by Real Estate Mortgage Network. I would like to introduce our presenter today, Ben Olson. Ben is the former Deputy Assistant Director for the Office of Regulations at the CFPB and is currently a partner at the law firm Buckley Sandler. Thank you, Ben.
Thank you, and it's great to be here. And just so you all know my background, the Office of Regulations at the CFPB is the group of attorneys who are responsible for writing the rules. So I was the deputy in that office that wrote the Qualified Mortgage Rule, the amendments to the Loan Originator Compensation Rule, and the other rules that are scheduled to take effect in January. Before that, I was also at the Federal Reserve Board when the original Loan Originator Compensation Rules were written. So that's my background, and today we're going to walk through largely the Qualified Mortgage Rule, but touch on loan originator compensation in particular and focus on the issues that should most affect you in your day-to-day lives. And one of the important points that I want to emphasize here at the outset is obviously this is a slideshow. We're not going to walk through the regulation word for word. I'm not even going to make you listen to me read all of these slides to you. There's a lot of information in here. Some of it is just for your reference, and there'll be more information coming. Also, another sort of goal here is, as often happens when new rules take effect, and particularly as you get close to the date they're going to take effect, it's a lot of change, and there are a lot of rumors and a lot of sort of misunderstandings out there. So you may be seeing things on blogs, message boards, just gossip from folks you're talking to, about what the rules do and don't do. And most of that's probably true, but probably a few things are based on misunderstandings, and certainly I spend a lot of my time talking to clients about, why the things that they may have heard, somewhere may not be quite right. So this will hopefully give you a good baseline for understanding the rules, and with the caveat that when you hear information out there, something that seems too good to be true may well, in fact, may not be true. So, okay, with that, let's dive right in and start with the ability to repay qualified mortgage rule. And the baseline here is that Congress, when it passed the Dodd-Frank Act in 2010, creating the Consumer Financial Protection Bureau, also amended the Truth in Lending Act to provide that a creditor shall not make a mortgage loan unless it first makes a reasonable and good faith determination based on verified and documented information that the consumer has a reasonable ability to repay the loan. So that's the baseline requirement we're looking at here. Reasonable ability to repay the loan according to its terms. And it also authorized the CFPB to create categories of loans that would be qualified mortgages. And those are loans that meet certain criteria and are therefore presumed to comply with this ATR requirement. And so it gets you additional protections from liability. And what's particularly important about this qualified mortgage status is not just the additional protections against liability, but the fact that the GSEs have announced that for the time being, they will only be buying qualified mortgages. So notwithstanding the fact that it's legal to make an ability to repay mortgage, and the CFPB has in fact encouraged folks to make loans outside the qualified mortgage space. This is the GSE policy right now, and that's dictating much of what's happening out there in the market. Okay. So onto the next slide, key point here, the rule takes effect on January 10th, 2014, and you may have heard rumors out there that there's legislation on the Hill to delay that effective date. That's true, there is legislation. It's been introduced in the House, but as those of you who probably follow these things know, it's much easier to introduce legislation than it is to get it passed. And even if that legislation were to pass the House, it's, I think, fairly unlikely that it would pass the Senate. So I think the reality is the rule, barring an extraordinary circumstance, will take effect on January 10th, and we all need to move forward assuming that it will. The rule, and this provides some detail as to what it applies to. Generally, it applies to any closed-end consumer credit transaction secured by a dwelling. And then there's a list of things here that are carved out, including HELOCs. I won't read you the whole list, but it's here for your reference. And an important point is this rule applies to anybody who is considered a creditor under the Truth in Lending Act and Regulation Z. So this is banks, non-banks. This rule applies to everyone who makes these kinds of loans unless they qualify for a particular carve-out. And there aren't that many of those carve-outs, but they're listed here on the slide. Okay, moving on. This slide is just an illustration of the different buckets that loans fall into under this rule. Basically you're either a non-QM or you fit within one of the many varieties of qualified mortgage. And I'm going to walk you through what all those things mean. Don't attach too much importance to what color a particular box here is. This is really just meant to illustrate the many flavors, as we sometimes said at the Bureau, of qualified mortgage. Okay, so this is the requirement for non-qualified mortgages, what are frequently called general ATR loans. And again, it mirrors the statutory requirement. The creditor must make a reasonable and good faith determination of the consumer's ability to repay at or before consummation of the loan. What happens after consummation doesn't necessarily affect the judgment as to whether this determination was properly made. So just because a loan goes bad doesn't mean there wasn't a reasonable determination of ability to pay. And the fact that a loan doesn't go bad for an extended period of time is typically evidence that there was a reasonable determination. And I won't read everything here, but the way this general standard works, the general ATR standard is that you have to consider and verify 8 items. They're listed here on the screen. And but once you've considered those, there's no minimum standards, there's no minimum debt-to-income ratio, you have to have no minimum amount of income, and there are no limitations on the types of products you can offer, except to the extent that the verification requirements do away with no-doc and low-doc loans. Otherwise, this is a much more sort of flexible standard, but it comes with increased liability, as we're going to talk about in a minute. Just want to mention on here, item 5, monthly payment for mortgage-related obligations. Sometimes folks are a little unclear as to what that is. Item 3 covers the monthly principal and interest, taxes and insurance payment. The mortgage payment for mortgage-related obligations would include taxes and insurance if they weren't escrowed. It would also include other things like homeowners association dues. All right, moving on. So the risks of noncompliance. So in other words, these are the penalties you could face for making a loan, or it's really the creditor, that the creditor faces for making a loan that does not satisfy the general ability to repay standard. So, in addition to actual damages and attorney's fees and costs, there's liability for all finance charges and fees paid by the consumer, but it's subject to a 3-year statute of limitations. So it's really 3 years of finance charges and fees. After the 3-year statute of limitation runs, there is still a defense to foreclosure that can be raised against the owner or assignee, or the original maker of the loan, if with no time limit on it. But it's not a per se bar to foreclosure. So that it's a defense to foreclosure. You can block foreclosure. That gets thrown out a lot. What it really is an offset. So the consumer, if they're able to establish, if they're in foreclosure, they're able to bring this claim, and then if they're able to establish that there was not a good faith, reasonable and good faith determination of ability to pay, they can get an offset against the amount owed of 3 years of finance charges and fees. Now, there's also been a lot of concern about regulatory and supervisory scrutiny. As I mentioned before, the CFPB has said, they don't want a mortgage market that is all QM, and they want folks to make loans, good loans in the ATR space. So I don't think sort of the concerns out there that The simple fact that you're making non-QM loans is going to make it more likely that you're subject to CFPB scrutiny. And similarly, the Bureau has tried to communicate that message to the prudential regulators, the FDIC, the OCC, the Fed, and we'll have to see what they do. But the real questions here are really around, since the GSEs have determined for the time being that they're only buying qualified mortgages, even though it's not against the law to make a non-qualified mortgage, if a loan is delivered to them that ultimately doesn't meet the qualified mortgage requirements, then that could be grounds for a repurchase demand. And so that's where it may be that a lot of these lines and these requirements that we're going to talk about in a minute come into play. Okay, so this is the liability protection that you get for making a qualified mortgage, and it's split in two based on the APR of the loan. If it's a higher priced qualified mortgage, then you get a rebuttable presumption of compliance. The higher priced loan is the same as for higher priced mortgage loans under Reg Z today. It's 1.5 or more points over the average prime offer rate. And what rebuttable presumption means is that while the creditor is presumed to have complied with the ability to repay requirement, the consumer can rebut, can defeat or overcome that presumption by showing that the creditor knew at or before consummation that the consumer did not have sufficient residual income to pay their living expenses and the mortgage payment on the loan. For other QMs, you get the safe harbor. So in other words, if the APR is less than 1.5 over APOR, you sort of are conclusively presumed to have complied with the rule. However, the issue is that the consumer could raise a claim and say the creditor did not meet all the requirements for qualified mortgage status, and therefore they're not entitled to this protection. So it's not a total bar against litigation. The creditor will still have to establish that it meets all the criteria for qualified mortgage status. Okay, so there are a couple of steps that you walk through to determine whether something is a qualified mortgage. The first, test 1 on this slide, is the loan features test. And a qualified mortgage cannot have a negative amortization feature, interest-only payments, balloon payments, unless the creditor is a very small creditor. And that means somebody who, with their affiliates, makes 500 or fewer first lien loans, mortgage loans, in a year and has assets under $2 billion. So those are extremely small creditors. There are other provisions of this rule that apply a little differently if you're a small creditor. I'm not really going to get into them because I don't think it's relevant for this audience, but just so you know, it's out there. So generally speaking, then, no balloon payments for a qualified mortgage and no terms exceeding 30 years. All right, test 2 is the underwriting test. And what's important to note here is it is any of these following items. These are not A, B, and C are not all things you have to meet. You have to meet either A, B, or C. So the first is the 43% debt-to-income option. And so this is a QM category that is established by the CFPB, and it requires that the creditor underwrite using very detailed guidance on underwriting and verification in Appendix Q to the regulation, and that based on that underwriting, the consumer's debt-to-income ratio does not exceed 43%. Appendix Q is based on FHA underwriting guidance, which creates some issues. It doesn't cover everything. When it doesn't cover something, you can generally rely on GSE underwriting guidance unless it would conflict with Appendix Q. For calculating the DTI, you're also going to assume that the repayment schedule on the loan, you're going to assume amortizing payments and the maximum interest rate in the first 5 years. So that's one option. A different option is to follow GSE or federal agency standards. And so if you can, as long as it's consistent with those agency or GSE standards, the DTI can be more than 43%, and you don't have to worry about Appendix Q. So the requirement here is that the loan be eligible for purchase, guarantee, or insurance based on the standards, not that it actually be purchased, guaranteed, or insured. And this is where it's expected at the early stages of the rule, most loans will be. It's expected that upwards of 80% of loans that are currently being made on the market will qualify for this. Now, this option, however, is intended by the Bureau as a transitional measure to sort of move the market from a time right now where it's extremely reliant on the GSEs to create a secondary market to a period where hopefully there's a functioning private secondary market again. So it is scheduled to expire in January of 2021, but can also expire earlier under certain circumstances. Specifically, your ability to rely on GSE standards will end if the GSEs leave conservatorship or receivership of FHFA. And there's legislation in Congress to address this issue and try and reform the GSEs. It's been moving slowly, and so it's really hard to determine if and when the GSEs will leave conservatorship. Also, the other federal agencies, and by that I mean HUD, the VA, and the USDA, Rural Housing Service, have the ability to define their own qualified mortgage categories. So they can engage in their own rulemaking. Until they do so, they're covered under the CFPB's rulemaking. But it's limited what the other agencies can do. They can't give you an out for the first test, which is the loan features test. So even if HUD were to say that you can make an interest-only loan, it still wouldn't qualify as a QM. But what they can do, and what HUD has actually proposed to do, is modify the criteria for instance, what gets the rebuttable presumption in the safe harbor. And so if HUD adopts their proposal, which they're expected to do before January, then, for instance, the mortgage insurance, the FHA premiums would not cause a loan to trip over the higher price threshold and receive the rebuttable presumption. And it would be much easier to make a FHA loan that would receive the safe harbor. VA and USDA have not moved forward publicly on their QMs yet. But if and when they do, then it would be their rule that applies and not this rule in terms of the underwriting standards. Okay, there are also options for very small creditors. I'm not going to get into those. So we'll move on to the third test. And this is also a test that the other agencies, HUD and the VA and USDA, do not have the ability to exempt folks out of. And it's the points and fees test. This basically provides that to be a qualified mortgage, the points and fees known at or before consummation cannot exceed certain thresholds that are tied to the loan amount. The one that is you'll most commonly encounter is 3% of the total loan amount for loans of $100,000 or more. There's slightly different thresholds as you go down the scale. $3,000 for loan amounts between $100,000 and $60,000, 5% for loan amounts of $20,000 to $60,000, and it goes on down from there. But we didn't put them all up here on the slide. Okay, so how do you calculate points and fees? What's in, what's out? So we'll walk through it in a couple of steps here. The first step is starting with the finance charge, which is something that's calculated today. The Bureau announced just 2 weeks ago that it is not moving forward at this time with its proposal to add additional items to the finance charge. So the finance charge is what it is. It's not going to change, and you can continue to calculate that the way you do today. So you start with that, and then you subtract certain items. You subtract interest. You subtract government mortgage insurance premiums, government program mortgage insurance premiums. You can also subtract private mortgage insurance premiums, but only to the extent that they do not exceed the FHA premium for the comparable product. If it's over the FHA premium, then you count the amount that is over the FHA premium, not the whole thing, just the amount that's over. But it does have to be mortgage insurance that is automatically refunded on a pro rata basis when the loan is paid off. Okay. The other thing you can subtract is bona fide third-party charges that are not retained by the creditor, the loan originator, or an affiliate of either. So this means that all the third-party settlement costs, to the extent they were captured in the finance charge, are out, unless it's kept by creditor, loan originator, or an affiliate. Although there are certain provisions, and we'll go through them, that come back in, and most notably, the mortgage insurance premiums, private mortgage insurance premiums, to the extent you have to count something there, the fact that it's going to a third party doesn't let you exclude it. So there are limitations on this bona fide third party exclusion, but generally speaking, that stuff's all out. Bona fide discount points, and this is tied to, again, where the loan's APR is in relation to APOR. You can deduct 2 discount points if the undiscounted rate, or the base rate, is no more than a point over APOR, and you can only deduct 1 discount point if the base rate is no more than 2 points over APOR. So the higher price the loan gets, the fewer discount points you can deduct. And what makes it bona fide is a test that the Bureau has been clarifying over time, and in October they did a webinar that sort of provided a little more detail on this. But basically it means that in order for a discount point to be bona fide, it actually has to buy down the rate from a rate that was available to the consumer. So if you think about this in terms of a rate sheet, in order for the point to be deductible here, the consumer actually has to have been able to, get the loan at a higher rate and avoid paying that point. So if there's sort of nowhere for the consumer to go up on the rate sheet and they're still paying points, then those aren't points you can deduct. Okay. Also, creditor paid charges, with the exception of loan originator compensation. So anything the creditor pays for is out. And so that includes, if the creditor is, if there's a premium pricing credit generated by the rate, the creditor can use that to pay down the points and fees, but except for, and the rule's very clear on this, except for loan originator compensation. Okay, a couple of notes on this. Loan level price adjustments are not bona fide third-party charges. Under the rule that was raised with the Bureau, they expressly rejected that argument. But the Bureau did say that to the extent you're recovering the LLPA through a higher rate, that's not included because interest is not included. And to the extent you're recovering the LLPA through points, those can be excluded if they are bona fide discount points, as we talked about before. But if the LLPA is being passed on to the consumer as a point that the consumer simply has to pay to get that loan, and they can't avoid it by accepting a higher rate, then it has to be included in points and fees. Okay, let's see. Just last point on this is that seller's points are generally excluded from the finance charge today. Nothing here changes, so a seller's point would not be included and could be used to offset other charges that might otherwise be included. Okay, and we're going to, by the way, if you're sort of wondering how you're going to follow all this, we're going to do some examples at the end of this to walk you through how this calculation looks on, with some actual loan numbers. Okay, so step 2, and the first 2 steps are really the crucial ones, and we'll speed up a bit after that. So step 2 is adding in loan originator compensation. And the statutory provision on this is pretty broad. All compensation paid directly or indirectly by a consumer or a creditor to a loan originator that can be attributed to the transaction at the time the interest rate is set. But the Bureau has carved out a few things. One, the Bureau said that to the extent the consumer is making a payment to a loan originator, specifically the broker, could be the creditor, I suppose, but generally not, that's already included in the finance charge. So to the extent under step 1, you've captured loan originator compensation, you don't have to double count it here, generally speaking. There's an exception to that, which I'll get into in a minute, but that's the general rule. A brokerages and creditors can pay their own employees without it being counted as loan originator compensation. So what you're really left with are payments from the consumer to the creditor or the broker, and payments from the creditor to the broker as being included You don't have double counting of payments from the consumer directly to the creditor or to the broker. So where you run into the risk of double counting is with payments from the creditor to the broker. And this depends on essentially whether it's a consumer-paid or a lender-paid transaction. And we'll get into that in a bit in the exceptions, but just something to remember is that lender-paid transactions are more likely to generate double counting because you're going to have the payment going from the consumer to the lender and then from the lender to the broker, and both those items are going to be counted. Whereas if the payment is going from the consumer directly to the broker, it's only counted once. Obviously, because of the prohibition on dual compensation, which we'll talk about in a minute, you can't have the broker receiving payments from both the consumer or the creditor, but nevertheless, this is a way to make the loan work under points and fees. Okay, and just again to reiterate, you cannot use seller or lender credits to offset loan originator compensation. All right, real estate related fees. This is extremely complicated. The basic idea here is, as everybody who's ever had to calculate a finance charge knows, there are a million exceptions. There are carved backs in, it goes back and forth. So the point here is there are certain charges that are excluded from the finance charge, certain real estate related fees like title fees, document prep fees, appraisal fees. And they're excluded from the finance charge, and what the Bureau said here is they come back in to points and fees if the creditor receives compensation in connection with the charge, or if the charge is retained by an affiliate of the creditor. So again, affiliate of the creditor this time, not an affiliate of the loan originator. And retained by means sort of not originally paid to, but ultimately retained by. So if you've got an affiliated settlement agent and they collect all this money at closing and then they pass it on to third parties and keep something for themselves to cover document prep fees or whatever it is, only that amount retained is counted against points and fees. So that's really the only point I wanted to make on this slide. And now to really speed up, so step 4, you're going to count credit insurance, debt cancellation, or suspension payments. Unlike the finance charge, doesn't matter if they're voluntary, they're still counted. All right, and you're going to count the prepayment penalty. So now, get into the examples. So this first example, and all of these examples are without taking bona fide discount points into account. So this sort of shows, how the rule works and how loans can fit under the points and fees cap before you even get to bona fide discount points. So to walk you through, and what you're going to see on each of these examples are different loan amounts from left to right, starting at 70, which as you may remember from the prior slide, gets a flat between $60,000 and $100,000, gets a flat $3,000 threshold for points and fees. Once you get above $100,000, it's 3% of the total loan amount. So that's what's reflected in the second row. And then we start walking through what the points and fees are on this transaction. So you've got lender fees of $895 across the board. Those are points and fees. Then you've got broker compensation of 2%. So that's reflected all the way across. Here you've got private mortgage insurance. And as you can see, it's 2.25 for this particular loan, but you subtract what the charge would be for an FHA loan. So you're subtracting 1 3/4, which leaves you with 50 basis points. So that's the amount that's reflected and included in points and fees. You have no affiliate fees here. So your total points and fees is in the next to last row, and as you'll see, there's only one transaction that goes over. So this is, excuse me. So we're going to talk in a minute about what you do if it goes over and what you can do to avoid that situation. But this is just an example of how it works. Obviously, the higher you go up the loan amount, the more likely, the easier it is to stay under points and fees, and that's why not to make predictions, because who can say what the regulators will do in the future, but it's in this $100,000 to $200,000 range where the 3% points and fees could really crimp access to credit, potentially, and especially for low to moderate income borrowers who are folks that generally speaking, policymakers want to see good credit extended to. So, if in the period after the rule takes effect, it starts to become clear that there is a restriction in credit for that group because of the 3%, it wouldn't surprise me at all to see that number get moved either by Congress or by the Bureau. But, we'll just have to see what happens there. Okay, so moving on to example number 2. All right, same loan amounts, same maximum points and fees, same lender fee. Here the broker compensation is 2 1/4, but we've got no PMI, and we've got affiliate fees of $150. So just to, after talking to the folks at REMN, it sounds like more likely than not, if you're running into an affiliate fee issue, it's going to be because of an affiliated AMC, and in that case, because of the rule on pass-throughs and the fact that you're only going to focus on, you're only including what's ultimately retained by the affiliate, then, a full like $150 appraisal fee that's paid to an AMC, and if a portion of that's passed on to a third-party appraiser, you're only going to count the amount that's actually retained by the affiliated AMC, and so that's probably more like 25 or 50 bucks. So this amount probably overstates what the affiliated fees would be on your loans. But then you add it all up, and as you can see, all of these loans pass points and fees with a decent amount of breathing room. Okay, so the third example is where the lender fee, you've got 2 1/2 broker comp, and the lender fees are waived. And you've got no affiliate fees, and as you can see again, no real issues with points and fees on these loans. So what happens though if you, to go back to the first example, you do realize that you're going to be over points and fees on the loan. So you've got a couple of options. The rule itself does not give you a cure, but as I mentioned earlier, it's not against the law to make a non-QM loan. So the issue is just generally going to be, what's the investor, what's the GSE going to be willing to buy? Right now the GSEs haven't, said that they're willing, what adjustments they might be willing to accept. So we'll have to see how that evolves over time. But it's possible the GSEs would create, some sort of a cure provision for their purposes. Although I think they'd want to be comfortable that, there's still going to be the sufficient protection from liability. So a lot of this hinges on, what's going to happen with litigation after the rule takes effect, and is it going to be, better, worse, or about the same in terms of risk as people are anticipating now. I think people are trying to be pretty conservative with risk, but they may get more comfortable going forward. Then what are your other options? Well, you could increase the rate, wrap the charges into the rate, increase the rate to generate a premium pricing credit to pay down some of the points and fees and get you under 3%. There are a couple of issues with doing that. One, if it happens late in the process, it's probably going to push your APR over the tolerance in TILA, which means you're going to have to redisclose and wait 3 days to close. So you could wind up kicking closing dates if this happens too late in the process. And then the other issue is just, a general concern about, the risk associated with kind of a bait and switch unfair practices claim or, fair lending liability. So if you're going to, be increasing somebody's rate late in the process, you're going to need to be really careful about, how you do that to avoid those risks. Now let's see, what you can't do is, and we'll get to this in a little more detail, but under the loan originator compensation rules, you can't vary the loan originator's comp. You can't reduce their comp to make this work under points and fees. Generally speaking, there's very limited carve-outs, which I'll talk about. So generally, this can't come out of the broker's pocket. The lender could eat the additional cost. You could also try switching from lender-paid comp to broker-paid comp if double counting is what's pushing you over. So there are a number of options there, and REMN, just like other folks, will be developing their procedures for how they want to handle this. Okay, so that wraps up the QM discussion. Now I'm just going to talk for a few minutes about the changes to the loan originator compensation rules. So what happened here is, as you may remember, Federal Reserve Board put in place general restrictions on compensating loan originators based on the terms of the transaction, and dual compensation, which is the loan originator receiving compensation from both the consumer and someone else, usually the creditor. Congress picked those rules up. Those rules took effect in April 2011, but Congress picked them up before they'd taken effect and put them into the Dodd-Frank Act, and specifically the Truth in Lending Act. So the Bureau came back through, did some cleanup on the rules, implemented what Congress did, and so now we have new rules that are taking effect on January 1. Generally speaking, they look pretty similar to the existing rules, and for instance, as this slide notes, the prohibition on dual compensation remains in place. So no changes there. Where there are changes is with the definition of loan originator. So who's covered by this rule? And the Bureau expanded this quite a bit. It now would apply to somebody who engages in loan origination activities in expectation of indirect compensation, as well as direct compensation. And this really clarifies something that was, kind of there under the original rules, but was that, while you may not be, a loan originator might not be directly compensated based on the terms of their transaction, if they're going to receive a bonus that's based on mortgage revenue or mortgage profits of their organization, then as far as the rules are concerned, they have an incentive to boost those revenues or profits by making whatever will be the most profitable loans. And so therefore, that compensation, that bonus compensation, needs to be restricted as well. Another way in which this has been expanded is the loan origination activities, because it's really an activities-based test. Whether you're a loan originator depends on what you do. So now taking an application, offering mortgage terms, arranging a mortgage loan subject to exceptions here, assisting a consumer in obtaining or applying for credit, negotiating. Loan negotiating was always in, but these are things that can now make you a loan originator. Referring a consumer to a loan originator can make you a loan originator if you're exercising discretion when you do it. So if the employee has the ability to sort of say, I'm going to send, this type of consumer to loan originator A and that type of consumer to loan originator B based on their financial characteristics, that person would become a loan originator under the rule. Also, people who advertise that they can perform loan origination activities are loan originators, even if they don't actually engage in those activities. So you want to be careful about who you hold out to the public as a loan originator. So what a lot of this means is that you really can only have properly licensed individuals discussing credit terms with consumers. So if you have support staff, operations staff, processing staff who are interacting with consumers and discussing loan terms, you need to be very careful about what those discussions look like. They really can't involve, any negotiation, anything beyond sort of confirming the loan terms that have already been agreed to. You can have a processor or an underwriter talk to a consumer to collect information to verify what's shown on the application. But really, other than that, you need to be careful about having your support staff talking to consumers, lest they become loan originators. Okay, permitted decreases in compensation. So this is what I was mentioning before in terms of if you go over points and fees, can you take it out of the broker's end? And the answer is pretty much not. Concessions are generally not permitted, and what the rule's concerned about here is folks doing kind of in the reverse what they can't do in the first instance. The rule doesn't allow you to compensate somebody to give them an incentive to sort of price certain people up. And similarly, it doesn't let you sort of start high and then take people down, at least through compensation. You're always free to offer somebody a lower rate, but you can't deal with that through the broker's compensation. There is a very, very limited exception, and it's here in the second bullet, that you can decrease it to defray the cost of an unforeseen increase in settlement costs. But the Bureau was, very clear in the rule here that they're concerned that this could be used to evade the rule, and they're going to monitor it very closely. So it's a very, very narrow exception. Okay. That brings us to the end of the presentation. One other point I just wanted to raise, although it's not on the slide, is what are the record-keeping requirements that apply here? And they are for a qualified mortgage, under the qualified mortgage rule, or could we apply an ATR rule? The record-keeping requirements apply to the creditor, and the creditor is required to maintain evidence of compliance for 3 years after the loan closes. But for LO comp, the record-keeping requirements apply to both the creditor and the broker, and both parties are required to retain records of all payments made or received, all loan origination compensation paid or received for 3 years after the payment. So not after the loan's closed, but after the payment is received. And so with that, I'll wrap up the presentation, and thank you very much for listening.
Thank you very much, and thank you, Ben, for this very informative webinar, and thank you to everyone who attended today's session. Real Estate Mortgage Network is committed to helping you navigate through this new QM regulation. If you have any additional questions, please contact your REMN AE or visit the REMN website at www.remnwholesale.com. Thank you again for participating today, and have a great day.